Okay. Who appears for the second and third defendants? Who appears for the second and third defendants?
It's my lord. She to read cards. Giwa, my lord.
You are for
the second and third.
And I'm wondering your dressing. Why are you not in your wig and gown?
I'm sorry, my lord. I just got the information about the Zoom, my lord, because I just came down. I'm so sorry.
And that should start with the necessity for you to dress properly before the court.
I'm sorry, my lord. I'm sorry.
Because anybody watching will wonder whether this one is a litigant or a lawyer.
I'm sorry, my lord.
No, what will your sorry do? You put off your mic, put off your video, and then go and dress properly. Yes, the matter is for judgment. Are we ready?
We are ready, my lord.
Learned Silk.
Yes, my lord.
Let me seek and obtain counsel's permission. You know, you people have decided to make the case very big.
Sorry.
According to your size. So the judgment is a 28-page judgment, and we are taking it via Zoom. So I don't know, are we okay if I highly summarize and concentrate on just the final
conclusion,
so that you read the details when they get copies?
My lord, we are all right
by you.
Very well, my lord.
All right by you.
It's all right, my lord.
Is that all right by you?
Lord, is all.
Hello?
Since we get the comprehensive judgment thereafter.
Yeah. You say what?
I said it is all right by me, since I know I will get full judgment thereafter.
Yes. Thank you. Ristikat, is that all right by you?
Yes, my lord, it's all right by me, sir.
Thank you very much. Yes. All right, this is the judgment of the court. The case before the court is a complaint by the claimant that Section 127(1) of the Constitution of the Federal Republic of Nigeria as amended was not complied with in his purported removal as the Auditor General of Kwara State, in that there is no resolution of the House of Assembly finding him guilty of misconduct and praying the governor to remove him from office, and that the governor has not removed him from office, and also that the letter of the chairman, Civil Service Commission, did not communicate to him his removal by the governor. By a complaint filed on 15th February 2022, the claimant is seeking the following reliefs. 1, a declaration that the claimant, in the discharge of his duties as Auditor General of Kwara State, did not commit any act of misconduct. 2, a declaration that his purported removal from office of the Auditor General of Kwara State by the defendants is in breach of Section 127(1) of the 1999 Constitution of the Federal Republic of Nigeria as amended, and in consequence null, void, and of no effect. 3, a declaration that the letter of removal from office of Auditor General of Kwara State written to the claimant by the Chairman Civil Service Commission dated 28 January 2022 is incompetent, null and void. 4, order declaring that the claimant remains the Auditor General, Kwara State, without a loss of his full salary, emoluments, privileges, and entitlements. 5, order of injunction restraining the defendants jointly and severally from harassing, intimidating, preventing the claimant from the performance of his job in any matter whatsoever, or removing him contrary to the provisions of Section 127(1) Constitution of the Federal Republic of Nigeria 1999 as amended. 6, the sum of 25 million naira general damages for the mental and psychological trauma and agony to which the defendants have subjected the claimant without just and reasonable cause. 7, declaration that Section 5(2) of the Kwara State Public Audit Enactment Law 2021 is null and void for being inconsistent with Section 127(2) of the Constitution of the Federal Republic of Nigeria 1999 as amended. Case of the claimant, we all know the case of the claimant as presented in court. We all know the case of the first. They are summarized here. I will not read them out, but they are there. Also, there is a summary of the case of the first, fourth, and fifth defendants. There is also a summary of the case of the second and third defendants. There is the final written address of the first, fourth, and fifth defendants. Learned counsel for the first, fourth, and fifth defendant final written address on 16th August 2024 by a motion of that date. Counsel formulated 5 issues for determination. In his paragraph 2.01, counsel said, until his removal on the 27th of January 2022 by a resolution of Kwara State House of Assembly, the claimant was the Auditor General of Kwara State. Issue 1 is more of argument of the preliminary objection that was filed on the 20th May 2022. Issue 2 is whether in the face of the facts, reliefs 1, 4, and 5 are not liable to be struck out for being ungrantable and or academic. Counsel answered in favor of the question and against the claimants. Issue 3 is whether Section 5(2) of Kwara State Public Audit Enactment Law 2021 is inconsistent with Section 127(2) of the 1999 Constitution. Counsel answered in the negative. That relief 7 cannot be granted because it is not in tandem with the pleadings which allege violation of Section 1271 of the Constitution and nothing in his averment relating to Section 5(2) of Kwara State Public Audit Reenactment Law. Issues 4 and 5, which relate to whether or not Section 1271 of the Constitution was complied with in the removal of the claimant and whether the claimant has proven his claim, were argued together. Therein, claimant set out the procedure contemplated by Section 127(1) of the Constitution. He set it out and made submission that the defendants properly complied. Final written address of the second and third defendants, the counsel to the second and third defendants filed final written address by a motion of 3rd July 2024. Counsel formulated 2 issues for determination as whether the removal of the claimant from office was in accordance with the provisions of the Constitution, with provision of section 1271 of the Constitution, and whether the claimant can be reinstated. Learned counsel made submissions similar to those of the counsel for the first, fourth, and fifth defendants, and answered question 1 in the affirmative and question 2 in the negative. Final written address of the claimant. The claimant counsel for his written address on 2nd October 2024 submitted 4 issues for determination. Issue 1 is whether there are proper parties before the court, and issue 2 is whether the removal of the claimant as Kwara State Auditor General on the address of the Governor of Kwara State House of Assembly is not brazenly unconstitutional, null and void. Counsel made submissions and answered in favor of the claimant's case. Issue 3 is whether defendant proved the allegation of misconduct against the claimant. Counsel answered in the negative. Issue 4 is whether the letter notifying the claimant of his removal as Auditor General is not unconstitutional and incompetent. Counsel argued and answered in favor of the claimant. The first, fourth, and fifth defendants reply on points of law. They are herein reproduced. Court's decision. This is where we come to the many children of the case. We are starting with preliminary objection of the first, fourth, and fifth defendants' counsel. The first, fourth, and fifth defendant can file a notice of preliminary objection by a motion or notice filed on 20th May 2022. The motion of 20th May 2022 was, however, not first identified and adopted by counsel during adoption of final written addresses. So the said motion is deemed abandoned. The counsel to the first, fourth, and fifth defendants, however, argued his issue 1 as whether the claimant's case as constituted is not incompetent and liable to be dismissed, which is the same thing with the preliminary objection. This is so argued for failure of claimant to join Kwara State House of Assembly as a defendant to this suit. Counsel cited the case of Green versus Green and Kemdili versus Kemdili. There is the response of the claimant counsel also. And after all my consideration, I came to the conclusion that the last paragraph, most so the joinder of the second defendant is not contested, neither is it an issue that the second defendant cannot be sued. So his presence in the suit, I agree, is as good as the presence of the Kwara State House of Assembly. There is no interest of the Kwara State House of Assembly that cannot be properly represented by defendants or defended by the second defendant. This objection lacks merit and is dismissed. Preliminary issues raised by the claimant's counsel. The claimant counsel raised 3 preliminary issues in his final written address, attacking the evidence of all the defense witnesses and concluded that in the circumstances, the evidence of these witnesses is worthless and incapable of establishing a defense against the claimant's case. The first preliminary issue raised by the claimant counsel is that the evidence of DW1 is worthless because he admitted in cross-examination that he never worked with the House of Assembly. After all consideration, I disagreed with the counsel. The second preliminary issue is that DW2 admitted in cross-examination that his written deposition was signed before his counsel in his counsel office, which renders the entire deposition of the DW2 on oath inadmissible by Section 112 of the Evidence Act. I relied on the case of I and others versus Giato and others. I took a long quotation in that judgment by Piobele Abraham George Will JCA. The quotation is 1.5 pages. So you will read it. After the long quotation, I said, adopting the reasoning in the above decision and applying them to this case, the facts and contention on the point being on all fours, I hold that the deposition of DW2 is competent and admissible and is good evidence before the court to be used in its evaluation, findings, and decisions one way or the other in its judgment. The third preliminary issue is that the only witness for the second and third defendants, DW3, admitted on oath that he appeared as counsel for the second and third defendants and was not only in court throughout, but he had the evidence of the claimant and was part of the team that conducted his cross-examination. After my consideration, I came to the conclusion. Okay, let me just read it. When DW3 testified on 16 May 2024, in cross-examination by the claimant counsel, DW3 said on 9th February 2024, I represented the second and third defendants as a counsel in continuation of the testimony of the claimant. This, to say the least, is unprofessional of counsel to appear as counsel for a party and in the same proceedings enter the witness box as a witness to the party he is representing. The evidence of DW3 he doubled as counsel and witness in the same matter is hereby discountenanced. Merits of the case. The defendant's counsel objected to the admissibility of some of the documents tendered by the claimant, and they were marked as Exhibit SOA 5, 6, 7, 8, 9, 12, 13, 15, 16, 17, 18, 20, 21, and 23 tendered and ruling reserved till judgment. After all my analysis, I think I rejected one or two of the documents. All the others were admitted in evidence. You will find the details when you get the judgment. The claimant's counsel also objected to the admissibility of the 7 documents tendered by the first, fourth, and fifth defendants and reserved reason to for final written address. The documents were marked as Exhibits BOB1 to BOB7 tendered and ruling reserved till judgment. Go and bring my laptop. Okay. In his final written address, learned counsel to the claimant submitted that none of the 7 documents which showed the participation of DW1 in as the maker, the recipient, or relationship in any manner whatsoever with the documents. After the consideration, I disallowed the objection and admitted the documents as exhibits BOB1 to BOB7. We again have to turn to yet another preliminary issue raised by the counsel to the first, fourth, and fifth defendants. So you people can see so many preliminary issues that you have clocked the court with. The first, fourth, and fifth defendants' counsel argued his preliminary objection as in issue 1 and argued yet another preliminary issue in his issue 2, which is whether in the face of the facts reliefs 1, 4, and 5 are not liable to be struck out. I reproduce reliefs 1, 4, and 5. And then with respect to relief 4, the response of the claimant counsel to this, after considering that the claimant ought to retire on 26 September 2023, is that if the court finds the removal of the claimant unconstitutional, the effect is that he remains the Auditor General with full right to his salary, emoluments, privileges, and entitlements until his due age of retirement on 26 September 2023. It is true that the claimant in cross-examination says I was employed as civil servant by the Kwara State Civil Service Commission. I was born on 26 September 1963. I am 61. And the court says, if the claimant was born on 26 September 1963, then he will be 60 years by 26 September 2023. It is also to be noted that the claimant had never ceased to be a civil servant subject to the Kwara State Civil Service Commission and the Kwara State Civil Service rules, as it is his evidence that he doubled as Auditor General and Permanent Secretary Audit Matters. This must probably inform the concession by the claimant counsel as to when the claimant ought to retire. I accordingly agree with the claimant's counsel that if the court finds the removal of the claimant unconstitutional, the effect is that he remains the Auditor General with full rights to salary, emoluments, privileges, and entitlements until his due age of retirement on 26 September 2023. With respect to relief 5, in view of the fact of this case and the admission of claimant, the claimant due to retire by 26 September 23, this relief is overtaken by events and I so hold. On relief 1, all the pleadings and arguments on whether or not the claimant committed any act of misconduct. Parties exchange series of pleadings, documents, and arguments to establish the guilt of the claimant and otherwise. The first question is, who found the claimant guilty of misconduct that he is challenging? At least that is not his case before the court. It is the defendants in their statement of defense who said that the Civil Service Commission found him guilty of misconduct. But even at that, there is no document citing misconduct of the claimant as basis for his removal as Auditor General of Kwara State. Even if that was the case, this court has always maintained that its jurisdiction in a matter of a complaint over the decision of an administrative panel resulting in a punitive measure is supervisory and not appellate. So this court does not have the jurisdiction to delve into the question of whether or not the claimant actually committed the offense of which he is accused. This stance is based on the Supreme Court decision in Bamigboye versus University of Ilorin, 1999, 10 Nigeria Law Report, Part 6, 22, page 290 at 348, where the Supreme Court held the High Court, and I put in court, now National Industrial Court, is merely to act in its supervisory jurisdiction or judicial control to ensure that the procedure laid down by law was observed by domestic tribunal. It is not to act as if it was sitting on appeal against the decision of the tribunal. See the recent decision of this court in Mr. Olaleye Aduo versus the Vice Chancellor, Ekiti State University, Ado Ekiti, and two others, suit number NICN/AK/08/2020, delivered on 5th March 2020 by KD Damulak J, of which the Court of Appeal affirmed disposition in the Vice Chancellor, Ekiti State University, Ado Ekiti, and two others versus Mr. Olaleye Aduo, appeal number CS/EK/45/2023, in its judgment delivered on 23rd November 2023. The Court of Appeal, Ekiti Division, held us. From the judgment, it is noticeable that the lower court initially took a correct position in its work to its conclusion in the judgment. The lower court vividly identified that the lower court, only had supervisory as against original jurisdiction over the decision of the appellants in dismissing the respondent from their employment. At pages 472 to 473 of the record of appeal, the lower court determined in its judgment as follows. The Court of Appeal then reproduced 1, 2, 3 paragraphs of the judgment, and then the Court of Appeal concluded. This court is also bound by those findings. In effect, the parties and the court this court are bound by the determination of the lower court that its jurisdiction is supervisory and not original in the matter before it. And then it says that indeed is the law. The implication is that this court has no jurisdiction to grant relief 1, even if the claimant had proven facts to that effect, because it will amount to the court sitting on appeal over such findings, and the court has no jurisdiction to so do. Relief 1 is denied for this reason and is hereby dismissed. Relief 7 prays as follows: a declaration that Section 5.7 of Kwara State Audit Law enactment is null and void for being inconsistent with Section 127(2) of the Constitution of Federal Republic of Nigeria. After all my analysis, I said it is the relief and the issue formulated thereon are mute and academic. Okay, let me just read. The pleadings of the claimant did not in any way disclose how the claimant is affected, aggrieved, or likely to be affected or aggrieved by the said section of the law, and what benefit will the grant of that relief confer on him. I do not see any utilitarian value in the grant of relief 7 to the claimant. That makes the relief and the issue formulated thereon a mute and academic, and spent, which the court, that makes the relief and the issue formulated thereon mute, academic, and spent, which the courts do not engage in. C. Otto and another versus INEC and others citations applied where the court held it is a settled principle of law that courts of law do not indulge in sheer academic exercise. Invariably, courts restrict themselves in dealing with live and unspent issues. In the case of the claimant, if the case of the claimant were, for example, that by reason of that section of the law, he would be forced to retire from service when he is not due for retirement, it would be a live issue. Accordingly, relief 7 fails and is dismissed. Reliefs 1, 5, and 7 having failed, what is left for consideration are reliefs 2, 3, 4, 6, and 8. These reliefs can be considered under the issue whether the claimant was lawfully removed from office as Auditor General of Kwara State. Central to this issue are sections 1271 of the Constitution, the letters of the first defendant to the Kwara State House of Assembly, dated 20th January 2022, Exhibit BOB 4, the proceedings and resolution of Kwara State House Assembly of 27 January 2022, Exhibit BOB 7, and the letter of the chairman of the Kwara State Civil Service Commission of 28 January 2022, written to the claimant, Exhibit SOA 22. I met, after some analysis, I reproduce Section 1271 of the Constitution. I reproduce what both counsel, in their opinion, is the procedure or the interpretation and application of that section. I say, except for the way the first step is coached by counsel to the first, fourth, and fifth defendants, I would have said both counsel are agreed and correct on the interpretation of Section 1271 of the Constitution. Suffice to say, the claimant's counsel puts it more correctly. Then I reproduce the evidence of DW 1 on the steps taken. It is a little long, but they are all reproduced here. I also reproduced the content of the letter of the first defendant, that's Governor of Kwara State, to the Kwara State House of Assembly, and it reads, I want, therefore, to inform the Honorable House that the matter was referred to the State Civil Service Commission for investigation. Mr. Adeye Osamuel was found culpable of the allegation of misconduct least expected from public officer of his status and capable of misleading the government and the public. It is my submission that this act, among others, contravene the code of conduct of public officer of his status. Consequently, acting on the provision of section 1272 of the Constitution, it is my address that the public officer, Mr. Adeye Osamuel, be removed forthwith from office as the Auditor General of Kwara State. This letter indicates that the governor conveyed the guilt of the claimant to the House of Assembly and addressed the House of Assembly that the claimant be removed. This gives the House no room to investigate and find the claimant guilty or not guilty of misconduct, and no room to pass a resolution that the claimant be removed. The provision of section 127 of the Constitution requiring an address supported by 2/3 majority of the House of Assembly praying that he be so removed for inability to discharge the functions of his office, whether arising from infirmity of mind or body or any other cause of misconduct, necessarily requires that the House of Assembly must first find the Auditor General unable to discharge the functions of his office or guilty of misconduct after giving him a fair hearing. It is not for the House to be informed by the governor that the claimant has been found guilty of misconduct, as that will amount to usurpation of the powers of the House of Assembly. The proceedings and resolution of the Kwara State House of Assembly of 27th January 2022 as BOB 7 at page 23 opens with message from the governor. The message is a reproduction of the contents of BOB 4, which I have just read above. Then on page 3, the proceedings is as follows. In the executive session, question was put on the request of His Excellency for the removal of the General Kwara State, Mr. Adeye Osamuel, and 20 honorable members voted in favor of the request. By leave of the House, Mr. Speaker directed the clerk to convey the resolution of the House to His Excellency immediately after sitting. From the above, it can be seen that the House did not investigate and find the claimant guilty of misconduct and did not pass a resolution praying the governor to remove the claimant as Auditor General for misconduct. It simply approved the request of the governor to remove the claimant. The Constitution did not say the governor shall remove the Auditor General and obtain the approval or ratification of the House of Assembly, upon which the Auditor General stands removed, as was done in this case, and confirmed by the evidence of DW1 when he said the provisions of the Constitution merely empowers the first defendant to remove the claimant, subject to the ratification of the Kwara State House of Assembly, that by the said resolution of the Kwara State House of Assembly, the claimant stands removed. This position of DW1 was reinforced by learned counsel for the first, fourth, and fifth defendants when he said in paragraph 2.01 of his final written address, until his removal on the 27th of January 2022 by a resolution of the Kwara State House Assembly, the claimant was the Auditor General of Kwara State. The Constitution did not say the governor shall seek the approval of the House of Assembly for permission to remove the Auditor General, but that the House of Assembly shall pass a resolution praying the governor to remove the Auditor General for inability to perform the function of his office or for misconduct, contrary to what was done in this case, as affirmed by the testimony of the DW1 that, I quote him again, that the resolution of the Kwara State House Assembly was as follows. This honorable House hereby approves the removal of Mr. Adeye Osamuel as the Auditor General of Kwara State, acting on an address of the Governor of Kwara State in line with Section 127 of 99 Constitution of Federal Republic of Nigeria as altered. The DW1 also said that the letter of the head of service was written in a representative capacity on behalf of the first defendant, the same way the letter of appointment as Auditor General is with SOA2 signed by the Chairman of Kwara State Service Commission, 28 January, reads as follows. I reproduced the letters and I came to the conclusion that the letters of appointment were written in representative capacity, but the letter of the head of civil service written on the 28th of January 2022 was written in a personal capacity, and that it merely informed the claimant of what transpired in the House of Assembly on the 27th of January 2022. The meaning of removed as contemplated by Section 127 of the Constitution is that there must be an instrument under the hand of the governor, or at least an official of the government, communicating the removal of the Auditor General by the governor to the Auditor General. Flowing from the above, I find and hold that Section 127(1) of the Constitution of the Federal Republic of Nigeria as amended was not complied with in the purported removal of the claimant as the Auditor General of Kwara State, in that there is no resolution of the House of Assembly finding him guilty of misconduct and praying the governor to remove him from office, and that the governor has not removed him from office, and also that the letter of the Chairman Civil Service Commission did not communicate to him his removal by the governor. On the whole, the case of the claimant succeeds in part, and for the avoidance of doubt, it is hereby declared and ordered as follows. 1. A declaration that the purported removal of the claimant from office of the Auditor General of Kwara State by the defendants is in breach of Section 127(1) of the 1999 Constitution of the Federal Republic of Nigeria as amended, and in consequence null, void, and of no effect. 2. A declaration that the letter from the Chairman Civil Service Commission dated 28 January 2022 did not communicate to the claimant his removal from office as Auditor General by the Governor of Kwara State. 3. A declaration that the claimant remained the Auditor General Kwara State without loss of his full salary, emoluments, privileges, and entitlements until 26 September 2023, when he retired from service. 4. A consequential order that the defendants pay to the claimant within 1 month of this judgment his salaries, emoluments, and entitlements from February 2022 to 26 September 2023, when he retired. 5. A consequential order that the defendants process the retirement papers of the claimant with his full benefits from 26 September 2023. 6. An order that the defendants pay to the claimant the sum of 500,000 naira as cost. This is the judgment of the court, and it is entered accordingly. I can't hear you. Maybe you do. We can hear you now.
Thank you, my Lord, sir. My Lord, we cannot thank you enough for the industry demonstrated in this judgment. We are grateful, my Lord, for your treatment of all the issues. The Lord will continue to grant your Lordship strength, and you will remain strong. Thank you very much, my Lord.
Thank you. Isamotu. Isamotu.
On behalf of the first, fourth, and fifth defendant, I also want to appreciate you for having listened to us painstakingly and to this judgment within the shortest possible time. My Lord, you are always good, and we wish your Lordship and the court the best.
Actually, I committed myself to doing it within the shortest possible time, because I imagined it was one narrow issue until I saw the children of the issues that you people batted. But already I had committed myself.
My Lord, we are all the same.
Yes, Risikat.
Thank you, my Lord. We are most grateful for the judgments, my Lord. Thank you so much, my Lord. And more wisdom to you, sir.
Thank you.
Yes.
Fresh copies of the judgment will be ready for collection by tomorrow. I did not hear any response.
My Lord, I said we are most grateful
Yes, I said copies of the judgment will be ready for collection by tomorrow.
We also appreciate your leadership for that.
We are grateful, my Lord.
We are grateful, my Lord.
All right. Is that all for the Zoom matters? Okay, that is all for the Zoom matters, so we shall all leave.
Thank you, my Lord.